Hi, this is Stacy, and we're going to cover Chapter 5 in your Yoder and Wise book, Leading and Managing, and we're going to talk about legal and ethical issues. I will let you look at the objectives. There's one page of objectives, and here is the start of the presentation. So Nurse Practice Acts. Nurse Practice Acts affect all facets of nursing practice and are the law within the given state or U.S. territory. You practice under the Nursing Practice Act that you have your license in. It defines three categories of nursing. So it gives direction to licensed practical, or we might call them vocational nurses, to licensed registered nurses, and to advanced nurse practitioners. It sets the state educational and examination requirements. It defines the function of each category of nurse, must be read to understand allowable actions for each of these categories of nurses. The main purpose of state boards of nursing are to ensure enforcement, act, and regulating those practitioners who come under the provision and preventing individuals not addressed within the act from practicing nursing, and to protect the public and ensure that those who present themselves as nurses are licensed to practice within the state. And you can find your Nurse Practice Act for the state of Iowa under the Iowa Board of Nursing. So what is negligence and malpractice? Negligence denotes conduct that is lacking care and typically concerns of non-professionalism. So most of the time it's non-professionalism. Malpractice sometimes refers to professional negligence. It's concerned with professional actions and is a failure of a person with professional education and skills to act in a reasonable or prudent manner. So malpractice, that'd be like if your patient had pain and you just chose not to do something about it. Why is it important that nurse managers know about negligence and malpractice? You mentor nurses, you supervise nurses, and the major causes of why nurses get in trouble with the law is negligence and malpractice, and in order to guide employees, you must be knowledgeable of these. Common causes of malpractice or negligence among nurses include failure to follow standards of care, communicate appropriately, access and monitor your patients, and act as a patient advocate. Both results either from the commission or omission, and both are non-intentional. Though patients suffer harm, there was never an intent intended to happen. So again, I'm going to say that again. Both result either from commission or omission, and both are non-intentional, though the patient suffers some harm that was never intended for it to happen. We'll talk about this a little bit more. Here are some examples of nursing negligence: failure to remove surgical sponge during surgical, causing ongoing abdominal symptoms for many years up until removal. And you can go ahead and read the rest of those examples of nursing negligence. Elements of malpractice, we will cover each element, what is it, examples, and nurses' responsibility for that. So that'll be part of your next slides that we're going to go through. So duty owed the patient. Easier to show is that a duty is owed the patient and is generally shown because a nurse has contracted to work for a given healthcare agency or facility. The level to which a duty is owed is the harder part to show and is based on the standards of care, which are minimum required actions. Standards are set by institutional policies and procedure manuals, job descriptions, level of education and experience, professional organizations such as the American Nurses Association, and specialty nursing organizations and accreditation standards. Nurse managers must ensure standards are known and followed and updated as needed. An example would be failure to monitor a patient's response to treatment. The duty is what you owe to the patient. Make sure to use broad terms when defining duty in organizational policies and procedures. For example, use provide a safe care environment rather than prevent harm. The latter may imply any harm befalling a patient in the nurse's fault. Nurse's duty includes interpreting and following physician orders. A duty undertaken must be performed correctly. For example, when attempting an IV or when intubating, persistence may be good. But at what point will a jury wonder why didn't they call in someone that knew what they were doing? Delay in treatment is generally defined as more than 4 hours. If an IV cannot be obtained, choose another route if able. So that just gives you a few examples of that. Breach of duty owed the patient, a synonym with failing to uphold the standard of care owed to the patient, generally shown at a court through testimony of an expert witness. To determine the appropriate standard of care to apply, expert witness gives testimony in court on a case-by-case basis, helping the judge and jury understand nursing care standards of care. In nursing malpractice suits, nurses serve as an expert witness whose testimony helps the judge and jury understand the application of the standard of nursing care. Expert opinions attesting to the standard of care may differ depending on whether the injured party is trying to establish the standard of care or whether the defendant, the nurse's attorney, is establishing an acceptable standard of care for the given circumstance. The injured party will attempt to show that the acceptable standard of care is much higher level than is shown by the defendant, such as the staff nurse or the hospital. The duty owed to the patient is breached by a responsible party. For example, a nurse fails to provide a safe environment by omitting to put the bed down. Example of failure to communicate change in patient status to healthcare provider. So again, we must operate within the standards of care. Standards of care, you can go to this website and find that, and so it gives you some recommendations. So as a nurse manager, this would be a good good website for you to bookmark and know about. Your Nurse Practice Act sets your standards of care. Published standards of nursing practice are out there, and healthcare facilities and policies and procedures set standards of care. So what is foreseeability? The concept that certain events may be reasonably be expected to cause certain results based on education and prior knowledge. Common areas of potential liability include medication error, patient falls, and failure to enact physician orders. Foreseeability is based on prior knowledge and failing to meet the standard of care that may result in harm. For example, omitting a previously ordered medication, such as an oral hypoglycemic medication, could have resulted in patient harm from hyperglycemia, or failure to assist a patient known to be at high risk for falls could result in the patient falling and breaking a hip. Foreseeability is necessary because the resulting injury was not intentional. Thus, the practitioner must know beforehand the type of injury that could occur from an omitted medication or a failure to safeguard the patient. So foreseeability goes along with you never give a med that you don't know what it is, and then as a manager or a leader, you set the example of knowing what each med is that you're going to give. Causation and injury. There must be a direct relationship between failure to meet standard of care and the patient's injury. It is not sufficient that the standard of care has been breached, but rather that the breach of standard of care must be the direct cause and effect factor that caused the injury. So let's read that again. It is not sufficient that the standard of care has been breached, but rather that the breach of standard of care must be the direct cause and effect factor for the injury. Some physical harm must be incurred by the patient before malpractice will be found against the healthcare provider. Although there are certain exceptions to the requirement that physical injury must result, they are extremely limited and usually involve a certain relationship, such as a parent-child relationship. There must be direct cause and effect to the injury. This is usually the most difficult to prove. But for the bed being left in high position, the patient would not, if the bed had not been left in high position, the patient would not have fallen. Another example situation, a fentanyl and a Marcaine epidural was ordered during labor. The mother received a mislabeled epidural of morphine, resulting in overdose. This necessitated Narcan reversal for the baby. No expert was able to determine that, but the mother overdose, the baby would have subsequently not had developmental issues. In this case, causation is not satisfied. Failure to provide adequate patient education may get you in this situation. Damages. The patient must show financial harm before courts will allow a finding of liability against the defendant, the nurse, or the hospital. Damages occur as a result of breach. The patient falls out of bed and breaks an arm, incurring damages. If the patient falls but is not injured, no damages are incurred. This may be poor patient care but does not satisfy the element of damages. Additional hospitalization time, future medical or nursing care needs, and the cost are considered damages. So how do we prevent malpractice lawsuits as nurse managers? A nurse manager must know the applicable standards of care and ensure that employees of the institution meet or exceed them. Updated standards, you need to update your standards as needed and ensure the appropriate committee reviews and revises outdated standards, policies, or procedures. Means of ensuring that the employee meets the standards of care include performing and reviewing all performance evaluations for evidence that the standards of care are met, reviewing randomly selected patient charts for standards of care and documentation, and inquiring of employees what constitutes standard of care and appropriate reference of standard of care within the institution. So they must be able to find your policy and procedure book. And if you went up to a nurse, they should be able to tell you about standards of care. Liability. Personal liability defines each person's responsibility and accountability for individual actions or omissions. Even if others can be shown to be liable for a patient injury, each individual retains personal accountability for his or her action. The law, though sometimes allows other parties to be liable for certain causes of negligence, known as vicarious liability or substituted liability. The doctrine of responsit superior makes employers accountable for negligence of their employees. Corporate liability is a newer trend in the law and essentially holds that the institution has a responsibility and accountability for maintaining an environment that ensures quality health care delivered for consumers. Corporate liability issues include negligent hiring and firing issues, failure to maintain a safety and physical environment, and lack of qualified, competent, or adequate staff. So malpractice concerns for nurse managers. We need to make sure that our assignments, our delegation, and our supervision is appropriate. It is our duty as a manager to orient, educate, and evaluate our employees. And we must not fail to warn them. So we need to make sure that we're evaluating on a regular basis and bringing to light if any of these malpractice concerns are present in your facility. Staffing issues, we got to make sure that we staff to the right ratio and the care level that is needed, and that we make sure that we have protective and reporting laws accessible to our staff. Assignments, delegation, and supervision. The nurse manager retains a personal liability for the reasonable exercise of assignments, delegation, and supervision activities. The failure to assign, delegate, and supervise within acceptable standards of professional nursing practice may constitute malpractice. Remember that delegation involves a transfer of responsibility for the performance of the task and skill without transferring of accountability for ultimate outcome. This is most often encountered when working with unlicensed assisted personnel. Assignments typically occur between professional staff members, such as when the nurse manager assigns patient care responsibility to other professional nurses working in the same unit or in the same institution or community healthcare setting. The level of accountability for the nurse manager who assigns as opposed to delegates is fairly obvious, although there can be some accountability in both instances. If it can be shown that the nurse manager assigned or delegated tasks appropriately and had no reason to believe that the nurse to whom the tasks were assigned and delegated was not competent to perform the task, the nurse manager potentially has neither no or minimal personal liability. On the opposite of that is true, though. If it can be shown that the nurse manager was aware of incompetency in a given employee, or that the assigned or delegated task was outside the employee's capabilities, the nurse manager substantially will be found liable for that subsequent injury to a patient. It is very important to know your nurse's abilities and skills. Duty to orientate, educate, and evaluate. This duty goes beyond that of continuing education department. Nurse managers must ensure that those whom they supervise continually provide safe and competent nursing care. So your responsibility as a nursing manager is to remember to respond to any allegation of incompetent or questionable nursing care. Implement means of helping staff members gain the needed skills or education to ensure competent care. And that would be like your nursing fairs, skill fairs that you have to go through. We're ensuring competent care there. Follow up as needed to ensure that a staff member has mastered the skill or has the needed information on which to base future nursing care. There is an example on page 78 in your book I think would be useful to read in regards to this. Failure to warn. If the institution has significant information and suspicion to warrant the discharge of an employee or force a resignation, subsequent employers should be advised of those issues. The state boards of nursing and agencies that oversee disciplinary actions of professional and non-professional staff should also be notified whenever there is a cause to dismiss an employee for incompetency or impairment, unless the employee voluntarily enters a peer assistance program. So that means if you fire a nurse for being incompetent or maybe abandonment of patients, you need to turn them into the Board of Nursing. Most states now recognize qualified privileges and allow previous employees to give factual, objective information to subsequent employers. So that means that the last employer where the nurse showed incompetency can report using just facts, not opinions, to the employer who is thinking about hiring that incompetent nurse. Note, however, that previous employees must have listed the nurse manager or institution as a reference before the privilege arises. Note, check your individual state laws before giving out that information. Make sure that you're within your human resource policies too. Okay, so let's talk about staffing issues as a manager. California has passed a mandate that contains a fixed number or a fixed ratio of nurse to patient. This does not consider the patient's acuity levels, but just based on numbers. Most states have safe staffing measures. So what's your responsibility as a nurse manager? You must alert hospital administrators and upper level management of inadequate nursing coverage. Upper management then decides what to do. Close a unit, hire new staff, resign nurses from other departments. Mandatory overtime is prohibited by most states. Some things to consider when floating staff. Nurses should be floated to units as similar to their own as possible. This requires a nurse manager to match a nurse's home unit and float unit as much as possible to consider negotiating with another nurse manager to cross-float a nurse. Open communication regarding staff limitation and concerns, as well as creative solutions for staffing, can alleviate some of the potential liability involved and create better morale among floating nurses. And thirdly, a positive option is to cross-train nurses within the institution so that nurses are familiar with 2 or 3 areas and can competently float to areas in which they have been cross-trained. So in some facilities, like they cross-train nurses from ER to ICU, or maybe med-surg to ICU, or med-surg to OB would fit within that statement. Protective and reporting laws. They ensure the safety and rights of certain classes of individuals. Examples include mandatory reporting for suspected child or elderly abuse and reporting certain categories of diseases or injuries to the CDC. including mandatory reporting of incompetent practitioners. So we shouldn't just fire incompetent practitioners, we should report them so they don't go to another place and use their incompetent skills. Nurse managers are often the individuals who are responsible for ensuring that correct information is reported to correct agencies, thus avoiding the potential liability against the institution. Many states now also have mandatory reporting of incompetent practice, especially through Nurse Practice Acts, Medical Practice Acts, and the National Practitioner Data Bank. Reporting incompetent practice often is restricted to issues of chemical abuse and special provisions that prevail if the affected nurse voluntarily undergoes drug diversion or chemical dependency rehabilitation. Mandatory reporting of incompetent practitioners is a complex process and involves both legal and ethical concerns. Finally, nurse managers must know what the laws require when reporting is mandated, to whom the report must be sent, and what individual institutions expect of its nurse managers. When in doubt, seek clarification from State Board of Nursing, hospital administration, or your professional association. Informed consent. The link I have here is a nice video to watch in regards to informed consent and what your responsibility is. Informed consent is authorization by the patient or the patient's legal representative to do something to the patient. It's based on legal capacity, voluntary action, and comprehension. So what is legal capacity? Legal capacity is usually the first requirement, and it is determined by age and competency. Age is generally 18, and competency involves the ability to understand the consequences of the action or the ability to handle one's personal affairs. State statutes mandate who can serve as representatives for a minor or an incompetent adult. The following types of minors may be able to give valid consent: emancipated minors, minors seeking treatment for substance abuse or communicable disease, or pregnant minors. Voluntary action, and the second requirement, means that patient was not coerced by fraud or deceived into allowing the procedure or treatment. Comprehension is a third requirement and the most difficult to attain. The law states that the patient must be given sufficient information in terms he or she can reasonably be expected to comprehend to make an informed choice. Inherent in the doctrine of informed consent is the right of the patient to have informed refusal. So the patient must clearly understand the possible consequences of refusal. So it's important that as a nurse manager, you understand informed consent and you understand what the nurse's role and the doctor's role and the patient's role is in informed consent. Here's another, this is on the National Council of State Boards of Nursing website. It's a good video about how social media can breach confidentiality without even knowing it. So I would encourage you to watch that, or at least put that away for a resource if you become a manager that you could share with your nurses. Also on that site is a lot of good videos about professionalism, substance abuse, so it's a good site to go check out and share with your employees if you become a nurse manager. So privacy is the patient's right to protection against unreasonable interference with reputation or right to be left alone, and confidentiality is the right to privacy of medical record. The nurse manager is cautioned to ensure that staff members both understand and abide by rules regarding to patient privacy and confidentiality. Interesting, patients should not be discussed with others. All information concerning patients should be given only in private and secluded areas. The patient's right of access to his or her medical record is another confidentiality issue. Although patients has a right of access, individual states mandate when this applies. Filling out incident reports. What is your role with that? It serves to alert the facility to risk management and quality assurance issues. Remember that the incident report should not be part of the patient's record. It may often be reviewed by all parties of a lawsuit, though. Include pertinent patient observation and care given the patient, and avoid including language of liability or language of opinion. Incident reports are considered internal documents, and those not discoverable are open for review by injured party or attorneys representing the injured party. In most jurisdictions where the question has arisen, however, the courts have held that the incident report was discoverable, and those open to review by both sides of the suit. So I would write your incident report thinking that this could go to court and I would have to be able to defend it. It is therefore prudent for nurse managers to complete and to have staff members complete incident reports as though they will be open records. It is also inadvisable to make any notations of the incident report in the official patient record, because such notations incorporates the incident report by reference, and there is no way to keep the report from being seen by the injured party or by the injured party's attorneys. I'll let you read through this question, and on the next slide I'll tell you the answer. And the answer to that was number 4. Employment laws. Nurse managers need to be familiar with several of the federal laws, including equal employment laws, Americans Act for Disability, and so forth, and we'll talk about each one of these, what it is, and why does a manager need to know about it. Equal employment opportunity laws. They prohibit discrimination based on gender, age, race, religion, handicap, pregnancy, and national origin. It also applies to private as well as public institutions. It defines sexual harassment broadly, and this has generally been upheld in courts, and nurse managers must realize that it is a duty of employers to prevent employees from sexually harassing each other. So that's why you go through sexual harassment training. Americans with Disability Act of 1990 provides protection to people with disabilities. Disability is defined as physical or mental impairment that substantially limits one or more of the major life activities of an individual. The fact that there is a record of such impairment to the individual is regarded as establishing that the individual has an impairment. The purpose of the Americans with Disability Act is to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disability, and to provide clear, strong, and consistent enforceable standards addressing discrimination in the workplace. The ADA is closely related to the Civil Rights Act of 1991 and incorporates the anti-discrimination privileges established in the Rehabilitation Act of 1973. The overall effect of this legislation is that a person with disabilities will not be excluded from job opportunities or adversely affected in any aspect of employment unless they are not qualified or are otherwise unable to perform job duties. It is essential that the job functions are defined by ADA as those functions that a person must be able to perform to be qualified for employment position. So what that says is that when you put out a job description, it needs to be very thorough so that it is clear that that person either can meet those job requirements or they cannot meet those job requirements. Occupational Safety and Health Act, that we know as OSHA, ensures healthful and safe working conditions exist in the workplace setting. Newer aspects that rules address include violence and bullying in the workplace, safe patient handling, ergonomic issues common in the healthcare industry, which would be like lifting patients. Among other provisions, the law requires isolation procedures. It gives us direction in how to handle radiation, proper grounding of electrical equipment, protective storage of flammable and combustible liquids, and gloving of all personnel when handling bodily fluids. The statute provides that if no federal standard has been established, state statute prevails, and nurse managers should know relevant OSHA laws for the institution and their certain areas. Violence is perhaps the greatest hidden health and safety threat in the workplace today, and nurses, as a large part of the healthcare professionals, are at risk for assault at work. The ANA reported that more than 1/3 of back injuries in nurses are associated with handling patients. Given this data and recognizing that there is simply no safe manual patient lifting, the ANA promotes legislation that would require hospitals and other healthcare institutions to develop programs to prevent work-related musculoskeletal disorders and eliminate manual lifting of patients. OSHA announced in 2012 that it had initiated a 3-year national emphasis program for nursing and residential care facilities in order to focus on workplace hazards that are most common in healthcare industries, including ergonomic stressors related to patient lifting. Family and medical leave, that you guys know as FMLA, balances the demands of the workplace with the demands of the family, allowing the employed individuals to take leave for medical reason. It includes care for the birth or adoption of a child, the care of a spouse, child, or parent with serious health problems, and health care needs of the employed individual, him or herself. The act was passed because large numbers of single parents and two-parent households in which single parent or both parent are employed full-time, placing job security and parenting at odds. The act is gender neutral and allows both men and women the same level of provision. So that means both men and women could take off for pregnancy. To be eligible under the act, the employee must have worked for at least 12 months in the facility and worked at least 1,250 hours during the preceding 12-month period. The employee can take up to 12 weeks of unpaid leave. An amendment to the act that was signed in 2008 permits a spouse, son, daughter, parent, or next of kin to take up to 26 weeks of leave to care for a member of the armed forces, including a member of the National Guard or Reserve who is undergoing medical treatment, recuperation, or therapy, or is otherwise in outpatient status, or is otherwise temporarily disabled on the retired list, or for a serious injury or illness. So there's just tons of things, laws that you need to know. And I guess what I would always say is that a nurse who can use her resources or his resources is a good nurse. So you need to go find where you can read about these laws and have them bookmarked, so if this comes up in your institution, you have a stable resource that you can reach out to. The Whistleblowers Law, enacted to prohibit healthcare professionals who are terminated in retaliation for speaking out against unsafe practices, reporting violations of federal laws, and filing lawsuits against employers, best known as the Winkler County Nurses Lawsuit. Essentially, whistleblower law states that no employer can discharge, threaten, or discriminate against any employee regarding compensation, terms, conditions, locations, or privileges of employment because employee in good faith reported or caused to be reported verbally or in writing what the employee had reasonable cause to believe was violation of a state or federal rule or regulation. So this means if you turn the facility in for Medicare fraud, they can't turn around and fire you, or they shouldn't be able to turn around and fire you. Most whistleblowers are internal. That is, they report misconduct to a fellow employee or supervisor within the agency. External whistleblowers are those who report misconduct to outside persons or entities. The cause of action in that lawsuit included violation of nurses' rights of free speech, due process, whistleblower retaliation, and interference with their business relationship that was certainly their employment status. Okay. Ethics. Ethics is an area of professional practice in which nurse managers should have a solid foundation because it is becoming increasingly more prominent in clinical practice today. Ethics may be distinguished from law because ethics is internal to an individual. It looks to the ultimate good of an individual rather than society as a whole and is concerned with the why of one's actions. Ethic and legal issues often become intertwined, and it may be difficult to separate the ethics from the legal concerns. Thus, the nurse manager must be cognizant of both laws and ethics in everyday management practice, remembering that ethical practice form the essential base of knowledge from which to proceed rather than giving straightforward answers. Review the facts of the case in the text and allow students to allow the nurse manager then to decide, is this a legal or ethical concern? And we could review the Terry Schiavo case if we wanted to. I gave you some ethical case studies that you're going to use for an assignment and apply these ethical principles. So ethical principles, essentially there are 8 principles to guide healthcare workers. Autonomy as personal freedom, the right to choose what will happen to oneself, as well as accountability for making individual choices. So fostering autonomy would be like allowing a patient who has lung cancer to smoke. That's their right. Beneficence is a duty to do good, is a basic obligation to assist others. So that you should have good intention every time you step into work and take care of a patient. Non-maleficence, do no harm. The nurse's obligation to avoid causing harm to the client. Veracity demands that the whole truth be told and in the terms that the individual can be expected to understand. Justice is the principle of treating all persons equally and fairly, and that's like when we give out resource. Are we doing it equally and fairly, like when we do organ donation? Paternalism may be used to assist persons to make decisions when they do not have sufficient data or expertise. It becomes undesirable when the entire decision is taken from the individual. Fidelity, it means keeping one's promise or commitments, and respect for others acknowledges the right of individuals to make decisions and to live by these decisions. Respect for others also transcends cultural differences, gender issues, racial concerns, and is the first principle in the American Nurses Association Code of Ethics for Nurses, and that is posted online for you guys at Code of Ethics. Excuse me. I'll let you read this and I'll give you the answer on the next slide. And the answer to that question is number 3. So the Nurses Code of Ethics, it's a formal statement that articulate values and beliefs of a given profession. It serves the following functions. The Code of Ethics informs the public of minimum standards of conduct for members of the profession. It outlines ethical considerations of the profession, provides guidelines for ethical practice by members of the profession, and it guides discipline, self-regulation. Professional codes of ethics are formal statements that articulate values, beliefs of a given profession and serve as a standard of professional actions and reflecting of ethical principles shared by its members. And so we have the Code of Ethics that can be found at the American Nurses Association, and it has a 9-point code that guides nurses understanding the extent of their commitment to the patient, themselves, other nurses, and the nursing profession. So finally, nurses and their nurse managers should ensure that the provision of the Code of Ethics are incorporated into nursing care in all clinical settings, along with establishing ethical standards for discipline. And nursing codes of ethics provide a basis for ethical analysis and decision making in clinical situations. How about ethic committees? With increasing number of ethical dilemmas in patient situation and administrative decision, healthcare providers are increasingly turning to hospital ethic committees for guidance. So when you're out in your preceptorship, you need to ask about their ethical committee. To form such a committee, the involved individuals should begin as a bioethical study group so that all potential members can explore ethical principles and theories. In most settings, the ethical committee already exists because there are complex issues dividing healthcare workers. An alternative to an ethical committee is the use of ethical grand rounds, which allow staff members who may later become involved in ethical decision making to begin to review all the issues and to become comfortable with ethical issues and resolutions. What are some future ethical issues that should be considered? The development of nurse leaders in healthcare delivery, the rights of the patient to refuse healthcare intervention, and the ability of patient advocates in today's healthcare structure. Other issues could be issues surrounding death and dying, including issues of hydration and nutrition for patients in persistent vegetative state, and the ability to perform competent quality nursing care in a system that is constantly or continually rewards cost-saving measures rather than quality care delivery, and that employs increasingly fewer professional nurses. As with ethical ground rounds, being aware of the issues and beginning to evaluate possible solutions will help nurse managers to better face ethical issues as they arise. Okay, and I'll let you read this. And the answer to this is number 3.